Our next speaker on the program is David Sykes. David is a Fairfield attorney and JFAN's legal counsel. David practices general law with a specialty in CAFO nuisance suits. He's also chairman of the board of Noah's Ark, which is an animal shelter here in Fairfield. And David will give us a legal update, including pending legislation and litigation. David?
Good evening. In talking with Diane in the weeks preceding the meeting, she kept asking me to please write out my speech and be very attentive to the 10-minute rule, because I think there's a hook that's going to come out the side. And I actually tried to do that a lot, but it didn't work that way. It's not how I wanted to communicate with you all tonight. The legal battle that's been going on now for over 4 years it's intense, and it's a story, it's a saga unto itself. And it's been my experience that talking to friends on the street and just hearing their understandings, it became clear to me that the legal circumstances that are going on in Iowa right now in terms of the CAFO fight are not clear. So I'm going to break my traditional silence tonight, and I'm going to take you into my confidence and give you an inside view of what is really happening in the legal arena. I'm not going to breach any attorney-client privileges or tell you something that that the third parties that are here tonight taking notes to go back to my adversaries. I want to talk slow enough so you get everything down. But I'm going to share with you some very important points. And to organize my thoughts, I decided to tell you, I'm going to give you 5 succinct points or stories. I'm going to start by saying that I'd like to thank the JFAN board for asking me to speak tonight. I'm very honored, and I'm privileged to share the stage with so many distinguished speakers. Tonight, my intention is to share with you an encouraging legal story that is generally just not known by the public. Given the limitation of time, I'm going to do the best I can, but I'm also going to participate in the panel at the end of the evening. And so those of you that have questions, I'll be able to take them there. So, by the way, Rich, since Dean had everybody dancing and singing, will you give me a wave at the 2-minute sign? Great, that way there's no way I can screw this up. Okay. Point number 1, going back to January, February last year, my colleagues, as some of you know, were out of town, well-known CAFO attorneys, Charlie Spear and Richard Middleton. We had our first big case in Batavia in January, February of 2016. We lost that fight. It was devastating for us, for the clients. I think everybody was disappointed. As time went by, Spear and Middleton informed me that, by the way, we're leaving the state. And all the hundreds of clients that we had in common in Iowa and the cases pending in court, well, we're withdrawing as counsel. It was a moment. It was truly a moment. I had to give some very serious reflection on, okay, now what? I'm not a litigator by trade. I'm more of a general practice attorney, business attorney, whatever. So I started talking to all of my colleagues, and to my great surprise and delight, I was able to connect with a very prominent attorney in Des Moines. His name is Steve Wandro of Wandro and Associates. And Steve, who I met years ago, it turns out that when in the late 90s or mid 90s, when Iowa hired counsel on behalf of Iowa to fight big tobacco, Steve was chosen as one of 4 lawyers to take that fight, and they ended up with a settlement from Big Tobacco for Iowa. I think it was about $1.3 billion. So Steve's a serious player. So I took the cases to Steve, and we looked at them, and again, to my glory, Steve, who himself is an environmentalist and someone who cares very deeply about Iowa, he agreed to take these cases with me. So as we speak, I think he felt a little sorry for me too. I kind of dragged myself into his office and told him this story, and he looked at me and he said, that's really something. But Steve Wandrow and his associate Jen DeCoke and I are the new legal team. And from that case that was lost in Batavia, we had to step back and analyze the case. I mean, you don't just expect to win everything, although it was sad. We realized that the Spear-Middleton plan was to talk to clients within 2 miles of the CAFO. The court clearly made it very clear that 1 mile or less was really where they felt the nuisance radius was. So we went back and we winnowed our larger group down to about 50 plaintiffs who all are within 1 mile or less, many half a mile from the CAFOs. And so we now have about 7 cases in court, 50 folks, and we were very cognizant of this case in the Prestige case that was also heard last year, and very similar factual patterns to what we have. A family was awarded $525,000 for being about a half a mile down the road from a Prestige farm CAFO. And they wanted trial. And for those of you that understand, you have a right to appeal. The other side appealed. And the Iowa Court of Appeals came down and denied their appeal. Said it was a good case. And so the $525,000 was awarded, and there's good case law on that circumstance, on that case, on the books. So, there's a new team in town. Now, going forward, point 2, of these 7 cases that we have left, there's one case called Hannah Michael versus Valley View Farms, which is also in Batavia, that was scheduled for trial last year, late in the year. And a common question of constitutional law came up, which kept going at Iowa Code section 65711. Now, for the non-lawyers in the group, what that law is, that is the Iowa Right to Farm law. That is the law that was passed in the 90s that gave CAFOs a significant advantage in protecting themselves from nuisance suits and made it very difficult to sue them. The Supreme Court in the mid-90s, in cases that came up, ruled that that law was unconstitutional. The Iowa Supreme Court. What happened though, in all subsequent cases, the defendants, the CAFO attorneys, kept bringing up the old Iowa law, 65711, claiming that the facts of this case were different enough to still have that law apply. It was different from the case that was ruled unconstitutional, where it was ruled unconstitutional. So we keep battling this law in every case. So finally, with Mr. Wandrow, we took the position that this question of constitutional law went across every case, and it's going to keep coming up over and over again, and actually the defendants agreed. And so we mutually appealed this. It's called a interlocutory appeal. That's before the case has gone to the jury. It's during a district court trial. We appealed it to the Iowa Supreme Court. And the Iowa Supreme Court, to our to our joy, I don't know if joy is the right word, but we're very pleased, they accepted the case. And so currently, as I speak to you, the Iowa Supreme Court is reviewing this Hannah Michael case. And Steve's position is that this law that covers all the cases that are in court today is unconstitutional on its face. In other words, if we win, there's no coming back from that. It's dead. And so that is going. I could go on, there's so much to tell you, but I have to keep going. So that is a real deal. Don't let anyone tell you other than that. Now, point number 3, again, another blow. The Iowa legislature this last summer passed another right to farm law, possibly anticipating the fate coming for the one that's now before the Supreme Court. And it's now called Iowa Code Section 65711A. Brilliant, And it is a tougher law than the law that we now have before the Supreme Court. I'm down to 2 minutes. My feeling is that the law that I've read, this new law, this 65711A, on its face, as I read it, is equally unconstitutional on a number of reasons that I'll go into later if we get into it. And so here's my hope, and here's the indecision or the uncertainty that resolves with us as people looking to stop CAFOs and the indecision for the CAFO industry. If the Iowa Supreme Court comes down and says that this current right to farm law, 65711, is unconstitutional, it will give a very elaborate opinion. Pages and pages of why. I believe those pages and pages of why will be very instrumental in challenging this new law. Now, many of my cases, in fact, all of my cases that are in court now will come under the old law, just because on a nuisance, you get a 5-year cause of action. And so most of our cases were in the dates prior to the new law being passed. But at the same time, I have 6 or 7 cases for me, people still calling my office with new CAFOs coming up. So it's a matter of time before one will challenge or be in a position to jurisdictionally challenge the new law. Now, this uncertainty that we're facing is the same uncertainty that the multi-billion-dollar CAFO industry is sitting there realizing. It's a two-sided coin, correct? I agree. Point 4. Tell me when the hook comes. Hook is ready. Okay. I filed with another legal partner, Brad Schrader, a senior partner in the Hartung Schrader firm. We filed our first case in Jefferson County last month. It's a case against the CAFO. Our client is within half a mile, and we're going to pursue that very vigorously. So now in closing, 30 seconds, don't hook me. We're now 4 years into this legal fight, and we're making progress. Please do not let anyone tell you otherwise. I've heard them say otherwise, and it's not true. Yes, it's been hard, some disappointments, some change in legal partners, but what would we expect would happen when we kicked a bear worth hundreds of billions of dollars? What did we think was going to happen? They were just going to lay down? No, we're in a fight. We're in a very, very rigorous fight. They say, I've heard it said for many years, that the wheels of justice move slowly. That's true, but they do move, and we are solidly in this game. We will, in time, legally break this grip. Thank you.
David, I want to make one thing perfectly clear. JFAN is not out here promoting lawsuits. We do everything we possibly can to prevent a CAFO from locating in a situation that will result in a nuisance suit. But we're certainly going to support people whenever we can't keep one from locating there, to do everything that's in their legal power to protect themselves from CAFOs.